California has one of the oldest and most sweeping assault weapons bans in the entire country, in place since 1989. For 35 years, gun owners in the most populous state in America have been told that these laws are settled, that the courts have upheld them, and that there is nothing to be done. But in the last 90 days alone, California's gun laws have been struck down by a federal judge, overturned by the Ninth Circuit Court of Appeals, and placed directly in the crosshairs of two separate pending Supreme Court petitions. And here is the part nobody is talking about. If the Supreme Court denies review on California's magazine ban, millions of California gun owners who currently own those magazines legally could be forced to either hand them over to police, destroy them, or face criminal penalties. Every word of this video comes directly from SCOTUS blog, the Ninth Circuit's own written opinions, Wikipedia's legal summaries on active cases, Duke Center for Firearms Law, NRA ILA, Newsweek, The Hill, Courthouse News Service, and official Supreme Court docket records. Let's get into it. To understand why California's ban is suddenly in serious trouble, you have to understand its history and how Bruen changed everything. California became the first state in the United States to pass an assault weapons law in May 1989, after the January 1989 Cleveland Elementary School shooting in Stockton. The Roberti-Roos Assault Weapons Control Act of 1989 restricted semi-automatic firearms classified as assault weapons. That ban has been updated and expanded multiple times since. California also enacted a separate ban on magazines holding more than 10 rounds in 2016 through Senate Bill 1446, and California voters later expanded it through Proposition 63, adding criminal penalties for possession. The plaintiffs, including Virginia Duncan and several others, along with the California Rifle and Pistol Association, challenged the magazine law on constitutional grounds, asserting violations of their Second and Fifth Amendment rights. But then, the Supreme Court issued its landmark Bruen decision in 2022, and everything changed. The Ninth Circuit vacated the lower court's previous decision on the California assault weapons ban and sent the case back to be reconsidered under the new standard. Judge Benitez again concluded the ban was unconstitutional. Judge Roger Benitez, the same federal judge who had struck down California's ban twice before, applied the Bruen framework and reached the same conclusion again. Benitez ruled that under a pair of landmark Supreme Court rulings expanding gun rights, the prohibition on semi-automatic rifle ownership is unconstitutional. He wrote that, Heller said quite clearly that it is no constitutional answer for government to say that it is permissible to ban some guns so long as other guns are allowed. This is not the way American constitutional rights work, California appealed. And the Ninth Circuit, operating under its own interpretation of Bruen, upheld the ban again. But crucially, that Ninth Circuit decision is now sitting at the Supreme Court, waiting to be reviewed. While the assault weapons and magazine cases work their way through the system, something remarkable just happened in California that sent shockwaves through the gun law world. On January 2, 2026, the Ninth Circuit held that California's near-statewide prohibition on open carry, applicable in counties with populations over 200,000 and covering roughly 95% of Californians, violates the Second Amendment under the Supreme Court's Bruen framework. Think about that for a moment. The Ninth Circuit, one of the most liberal federal appeals courts in the country, just struck down one of California's core gun restrictions. The decision was written by Circuit Judge Lawrence Van Dyke, a Trump appointee, and joined by Judge Kenneth Lee, another Trump appointee. Van Dyke wrote in the majority opinion, "In our nation's history and tradition, open carry was widely recognized as being central to the Second Amendment right. A ban on that which is at the core of the Second Amendment is not a minimal burden on the Second Amendment right. The ruling applies to the 95% of Californians who live in counties with more than 200,000 residents. The decision creates a direct conflict with another federal appeals court, which upheld New York's open carry ban months earlier, the kind of split that often draws Supreme Court attention. California's urban open carry ban that flatly prohibits all open carry in the areas of the state where 95% of the people live is thus unconstitutional," the majority concluded. Governor Gavin Newsom responded furiously. Newsom's office stated, "California just got military troops with weapons of war off of the streets of our cities, but now Republican activists on the Ninth Circuit want to replace them with gunslingers and return to the days of the Wild West." But strong words from a governor do not reverse a federal court ruling. California is now reviewing its options, including seeking full panel review from the broader Ninth Circuit. Now here is where it gets most serious for California. There are 2 active Supreme Court petitions, both directly targeting California gun laws, that are sitting at the court right now in a state of extreme legal tension. Case 1. Duncan vs. Bonta, California's magazine ban. California has prohibited the manufacture, import, sale, and transfer of large-capacity magazines since 2000, defined by the state as any ammunition-feeding device with the capacity to accept more than 10 rounds. In 2016, the state banned the possession of such magazines and required any lawfully possessed magazine to be surrendered, permanently altered, or destroyed. The NRA executive vice president stated, "Tens of millions of Americans lawfully own hundreds of millions of the magazines that California bans. The Supreme Court should take this case to vindicate the rights of Californians and reaffirm that the Second Amendment prohibits the government from banning common arms." The Ninth Circuit upheld the ban in a 7-4 decision. The majority concluded that magazines are accessories rather than arms, and thus not covered by the Second Amendment. The petition for certiorari emphasizes that this ruling clearly contradicts the Supreme Court's Second Amendment precedent, which establishes that common arms, including magazines owned by tens of millions of Americans, cannot be banned. The court has distributed Duncan vs. Bonta to 8 consecutive conferences without taking action, one of the longest relist streaks in recent memory for a Second Amendment case. Gun owners in California are currently protected by a separate court-issued hold while this plays out. But if cert is denied, that hold lifts and owners could face criminal penalties for possession. That last point cannot be overstated. If the Supreme Court denies review, millions of California gun owners who currently own legal magazines could face criminal charges overnight. Case 2. Miller vs. Bonta, California's assault weapons ban. The California assault weapons ban case, Miller v. Bonta, remains pending in the Ninth Circuit, held in abeyance pending the resolution of Duncan vs. Bonta. In light of the Ninth Circuit's decision in the Duncan matter holding that large-capacity magazines can be restricted, it is likely that assault weapon bans need to be addressed at the Supreme Court before the Ninth will recognize the Second Amendment as a serious right, if at all. After a round of supplemental briefing, the Ninth Circuit has resubmitted Miller vs. Bonta, which involves California's assault weapons ban, for decision. Depending on the outcome, this case could well push the court to take up the assault weapon issue as soon as next term. Here is the core legal argument that is making California's ban so legally precarious right now. Smith and Wesson Brands v. Estados Unidos Mexicanos recognized that AR-15 and AK-47 style semi-automatic rifles are widely legal and bought by many ordinary consumers, and observed that the AR-15 is the most popular rifle in the country. Cook County, and by extension California, bans them. The Bruen test requires the government to show that a restriction is consistent with the nation's historical tradition of firearm regulation, going back to 1791. Benitez wrote in his ruling that there were no founding-era dead ringers or historical twins for California's ban. There are no founding-era dead ringers or historical twins. A historical twin is not unimaginable. It could have been the case that the early states prohibited ownership of rifles and muskets with bayonet attachments or firearms capable of multiple shots without reloading. One could imagine the states prohibiting private possession of cannons or Gatling guns. There were no such restrictions, he wrote. That is the core problem California cannot escape. There is no founding-era equivalent of a semi-automatic rifle ban. There is no historical tradition of banning the most popular rifle in America. And under Bruen, that means the ban cannot stand, at least according to multiple federal judges who have reviewed it. 10 states and the District of Columbia currently ban assault weapons in some form, while 14 states and the District of Columbia restrict the possession of large-capacity magazines. All of these laws have been challenged in court by gun rights groups. Here is the complete picture of California's gun law situation as of April 2026. California's open carry ban, struck down by the Ninth Circuit on January 2, 2026, covering 95% of Californians. California's magazine ban, sitting at the Supreme Court in Duncan vs. Bonta, relisted 8 consecutive times. If SCOTUS denies cert, millions of gun owners face criminal liability for legal property they currently own. California's assault weapons ban, pending in the Ninth Circuit in Miller v. Bonta, awaiting the Duncan outcome before a final decision. And at the same time, the Supreme Court has a 6-3 conservative majority, with multiple justices who have already written in their official statements that AR-15 bans are constitutionally questionable, that the Ninth Circuit's approach is wrong, and that the court should take up the issue soon. The status of semi-automatic rifles like the AR-15 is probably the most prominent issue concerning the Second Amendment yet to be decided. The AR-15 is said to be the most popular firearm in the United States, and therefore is arguably in common use. The court should and presumably will address the AR-15 issue in the next term or two, according to Justice Kavanaugh himself. California gun owners, whether you own an AR-15, an AK-47, or a magazine that holds more than 10 rounds, the legal battle for your rights is playing out right now in real time. Subscribe to this channel, share this video. The next ruling could change everything for every gun owner in California.